Yes, Ms. Kaufman.
So, my lords, my lady, I had finished running through the very substantial body of convention jurisprudence relating to Article 3. I'm now going to move on to my third point, which was that Article 3 isn't unique in any sense in implying or having within it an implied operational duty to conduct a criminal investigation.
Before you turn to that,
sorry.
there's just one point. These cases all establish, if you're right, that there's a duty to the victim to investigate the crime or wrongdoing committed against him or her. But in this case, as I understand it, what you're saying is because of the police failure properly to investigate the crime against an anterior person, and therefore it might be said on the basis of those cases infringe their Article 3 rights, your Article 3 rights have been harmed.
So I'm going to take that point. If I might, can I take it right at the end?
Of course you may, yes.
Because that...
Provided you take it, that's fine.
I will certainly take it.
Don't let me take you out of your
That's
order.
going to be at the end, because that, of course, is premised upon there being an investigative obligation
Oh, yes,
of an
yes, yes.
operational
No,
nature.
it's entirely fair. Yes,
Yes.
absolutely.
So I
Thank
want to
you.
establish that first, and then we'll look at its constituents.
Understand. And you're now going to show us that this isn't an exceptional notion that there should be an investigation.
It's not exceptional. It applies across the absolute rights for reasons I've already indicated are not at all surprising given the fundamental nature of those rights and the status they enjoy under the Convention. Now, I'm going to take the court to Article 2 and to two cases, Osman, which we've looked at briefly, and Menson, which we've looked at briefly. And I hope to make good my point about the cascade by looking at these cases. So Osman is in volume 44, tab 32, relevant paragraph 115. Did I say 44? 4, tab 32. I'm so sorry. Volume
Don't worry.
4.
Not as bad as that, Miss Campbell.
It feels like that.
Not yet, anyway.
Volume 4, page 1382.
Yeah, as you say, we've looked at this a little.
We have looked at it, but I apologise because I want us to look at it again because I really need to drive home how the cascade works, and it's well exemplified in this case, coupled with Menson. So 115. The court notes that the first sentence of Article 2.1 enjoins the state not only to refrain from the intentional and unlawful taking of life, but also to take appropriate steps to safeguard the lives of those within its jurisdiction. Now, pausing there for a moment, we have seen in the Article 3 cases that precisely the same obligation is derived from Article 3 in conjunction with Article 1. Requirement to take steps to safeguard the lives, or rather to safeguard persons within the jurisdiction from ill treatment. It is common ground that the state's obligation in this respect extends beyond its primary duty to secure the right to life by putting in place effective criminal law provisions to deter the commission of offences against the person, backed up by law enforcement machinery for the prevention, suppression and sanctioning of breaches of such provisions. Now, that wording can be read as imposing pure structural duties. So the duty to criminalise by putting in a body of laws, and then the duty to put in place the necessary executive structures to ensure that there is a law enforcement machinery in place which will serve the purpose of prevention, suppression and sanctioning. But the court doesn't stop there, because the court goes on to derive from that lower order duty to put in place the law enforcement machinery for the prevention, suppression and sanctioning of breaches of such provisions, the Osman duty. The Osman operational duty is derived from that. And that comes from reading paragraph 116. So first of all, they look at the difficulties in policing modern societies. They recognise there has to be a fair balance, but they then go on to hold that there is a duty to take operational steps. We'll come back to this, but they reject the government's argument at the bottom of page 1382 as to how limited a duty the government was prepared to concede should arise. They think that's too restricted, and they say, in terms 1383, Such a rigid standard must be considered to be incompatible with the requirements of Article 1 of the Convention and the obligations of contracting states under that article to secure the practical and effective protection of the rights and freedoms laid down therein, including Article 2, for the court, and having regard to the nature of the right protected by Article 2, a right fundamental in the scheme of the Convention, it is sufficient for an applicant to show that the authorities did not do all that could reasonably be expected of them to avoid a real and immediate risk to life of which they ought to have had knowledge. This is a question that can only be answered in light of all the circumstances of a particular case. So we have a clear operational duty which requires an examination of the actions taken on the ground at an operational level by particular individual police officers, where the test is one of applying a reasonable standard, and that operational duty derives directly from the duty to criminalise and put in place the law enforcement machinery to prevent, suppress and sanction breaches of the criminal law. If we then turn back to tab 28 and the Menson case. Now, the Menson case was a horrific case of a brutal killing by individuals who had no connection whatsoever to the state. And Mr. Menson was burned alive in the street and died. And the police, it was said by the Menson family, failed in their duty to investigate. If we turn to page 1202 in tab 28, at the bottom paragraph, we can see there is no question of complicity in this case, none whatsoever. The court observes that the applicants have not laid any blame on the authorities of the respondent state for the actual death of Michael Menson, nor has it been suggested that the authorities knew or ought to have known that Michael Menson was at risk of physical violence at the hands of third parties and failed to take appropriate measures to safeguard him against that risk. That is, the Osmond duty was not breached. The applicant's case is therefore to be distinguished, it's page 1202, it is to be distinguished from cases involving the alleged use of lethal force either by agents of the state or by private parties with their collusion, and then there are a list of examples of cases of deliberate ill treatment, or, third line down 1203, in which the factual circumstances imposed an obligation on the authorities to protect an individual's life. For example, where they have assumed responsibility for his welfare, or where they knew or ought to have known that his life was at risk. That is, they are totally distinguishable from cases where there is an ancillary adjectival duty to investigate the state's own breaches of its substantive obligations under Article 2. And then we get this. However, the absence of any direct state responsibility for the death of Michael Menson does not exclude the applicability of Article 2. It recalls that by requiring a state to take appropriate steps to safeguard the lives of those within its jurisdiction, Article 2.1 imposes a duty on the state to secure the right to life by putting in place effective criminal law provisions to deter the commission of offences, and we see the repetition of the wording in 115 of Osman. And then this, with reference to the facts of the instant case, the court considers that this obligation requires, by implication, that there should be some form of effective official investigation when there is reason to believe that an individual has sustained life-threatening injuries in suspicious circumstances. And then they set out the requirements of that investigation. 4 lines further down, the investigation assumes greater importance where death results, having regard to the fact that the essential purpose of such an investigation is to secure the effective implementation of the domestic laws which protect the right to life. And then it looks at allegations where the state has been involved in the death and how the requirements of the investigation have been qualified by the court where it is state ill treatment leading to death. And at the bottom paragraph, what form of investigation will achieve these purposes may vary in the circumstances. However, whatever mode is employed, the authorities must act of their own motion once the matter comes to their attention. They cannot leave it to the initiative and so forth of the state. And then on 1204, although there was no state involvement in the death of Michael Menson, the court considers that the above-mentioned basic procedural requirements apply with equal force to the conduct of an investigation into a life-threatening attack on an individual, regardless of whether or not death results. So they're even saying there, and it's conceded by the defendant in any event, that what is said in relation to Article 2 applies equally to Article 3. So what we have here is a very clear explication of the cascade that I described earlier, and how the operational duty to protect where there is a real and immediate risk to life, of which the authorities ought to have known, and the investigative duty to conduct an effective investigation where there is a credible allegation that an individual has been subjected to deliberate ill treatment of a severity sufficient to engage Article 3 or to cross the threshold of the kind of treatment prescribed by Article 3, derives from the very, very self-same duty. That is, the duty to criminalise and put in place law enforcement machinery. And that has major implications for the defendant's arguments across the board, both in relation to the relevance of public policy and in relation to its attempts to limit the ambit of an investigative obligation to something that is systemic or structural as opposed to operational. So we have a clear explication. We have a rational, principled basis for the implication, a basis which is situated in long-standing convention principle. The convention is a living instrument. It must be rendered effective and practical, not theoretical and illusory, and to that end, all the requirements spelled out in Osman and in Menson fall to be derived and implied. So, taking all that and moving forward, in our submission, there is no rational basis, therefore, to limit the investigative obligation to a structural duty, that is, to put in place the police force as the machinery which is going to conduct investigations, and to leave it at that. Firstly, the convention jurisprudence that I took the court to before lunchtime, finishing with these cases now, makes it absolutely clear that there is an operational investigative obligation of a criminal nature, and we cannot put that under the carpet. Secondly, the case of Azanov, on which the defendant has relied, in no sense undermines the existence of an operational as opposed to a structural duty. Indeed, Azanov itself, it's volume 3, tab 17, I don't need to take your lordships to it, my lady, but at paragraph 102, they recognise and rely themselves upon Articles 1 and 3 read in conjunction, imposing a duty to secure the right to those within the jurisdiction as the basis for the investigative obligation that they find to be implied. That is precisely the same rationale for the imposition of the investigative obligation that applies in respect of the actions of private persons. So Azanov does not undermine us. But further, the appellants and the Secretary of State's acceptance that there is an operational protective Osman duty, as I said at the outset, completely undermines their case for limiting this duty in relation to investigations, criminal investigations, to a duty to provide the necessary structure. They accept the duty to put in place law enforcement machinery for the prevention, suppression and penalisation of criminal ill treatment. They accept that that duty itself gives rise to an operational duty, albeit the Osman duty. There is no rational reason, focusing on the conventional rationales and principles for a moment, because that's where we are. We're not looking at public policy arguments, we'll look at those later, but focusing for a moment purely on the convention principles and rationales that gave rise to or life to these obligations, there is no rational basis to say yes to the operational Osman duty, no to the investigative obligation. And there is this further reason. Those two duties are permeable. They each carry aspects of the other. If the court would look for a moment at volume 2 and tab 13, MSP 554, this is taking us back to the Smith case.
Yep.
Smith and Van Colley, and to the speech of Lord Brown at page 554, paragraph 126.
Thank you.
There, Lord Brown asks, is it really possible to find a satisfactory basis upon which to distinguish this class of case? Now, it will be recalled that the class of case that was being considered in Smith and Van Colley was the class of negligence case, which was covering the same territory as the Osmond duty, the protective obligation. The complaint in this case was of a failure to protect somebody whose life was at real and immediate risk in circumstances where the police should have known about that risk. Is it really possible to find a satisfactory basis upon which to distinguish this class of case from all the many other situations in which the Hill principle would clearly apply? So the Hill principle extends to circumstances both where there is a failure to take measures to protect, the Osmond duty, and that's exactly what the outcome and holding of Smith was, and again Michael, but it also covers cases, Hill itself was such a case, where it extends to a failure to investigate. Because the complaint in Hill was that the mother of one of the victims complained about failures to investigate earlier offences of Sutcliffe, with the result that her daughter was killed. And he answered the question at paragraph 130. Well, he did it in many ways, but his third reason is given at 130, and he says this: although it's tempting to regard the police's function from which this duty is said to spring as something different from that of investigating crime, the function which prompted the Hill principle, as perhaps the exercise of a protective function, this really would be a false dichotomy. Not only are the threats themselves criminal offences, which like other reported crimes fall to be investigated, but as I indicated earlier, the police have to investigate many other risks of physical violence which come to their attention. And if we just examine for a moment the sorts of cases such as this with which we are concerned, cases of serial offenders, then the way in which the protective obligation falls to be discharged is very, very frequently going to be, and exclusively be, by way of investigating allegations of offences by the same perpetrator. So in the domestic violence situation, you have a woman who is subject repeatedly to physical violence and abuse by her husband. She complains in relation to one or more of those attacks. In order for her to be protected once they become aware of the complaint, what do they need to do? They need to investigate. They need to investigate so they can arrest, so they can charge, so they can remove him, so they can prosecute him, get him out of the way, stop him from offending against other people. The two are completely permeable, and so it is a totally false dichotomy to say that it is possible to have an operational duty to protect but not to investigate. It makes absolutely no sense and is a totally incoherent position at which the appellant has arrived. Next, they say, the investigative duty is restricted to cases of state complicity. I haven't got time to go into these cases. I can say this very briefly. All the cases that the appellant relies upon to show that the investigative obligation is restricted to cases of state complicity are cases where what was in issue was state complicity. In none of those cases do they for a moment suggest that it is only in cases of state complicity that the investigative obligation can arise. As I indicated earlier, those cases are concerned with a different kind of duty to investigate, which does not derive from the state's obligation to put in place criminal law provisions and make sure an effective machinery is applied in practice. That's so for Azanov, Gefgen, El Masri. All those cases are not on point. It's the same in relation to Middleton, it's the same in relation to Ascani, which are new authorities to which the court hasn't been taken, but which we were sent this morning.
What about Smith and Oxfordshire Assistant Deputy Coroner?
Well, precisely, that's all about the state's own failings.
Yeah.
It's about the...
I mean, the head note is wrong. The investigative obligation under Article 2 arose only in circumstances where there was ground for suspicion that the state might have breached a substantive obligation. That should be read under the in the light of the context.
Yeah, yes, because what was an issue there was, are you required to investigate where there is not a credible allegation of a substantive breach? So it was, the focus was on the state's conduct. Must you investigate even if there's no allegation of a substantive breach, or is it
So
limited?
what is the test for investigation? I mean,
So the test for investigation...
in a non-state involvement situation.
In a non-state involvement situation, the test is there must be a credible allegation of ill treatment by a private person, which is deliberate ill treatment that crosses either the Article 2 threshold, the Article 3 threshold, or the Article 4 threshold. So it's a very, very high bar. It's not any form of ill treatment. It's not some common assault. It's cases like rape, cases of very, very serious violent assaults, cases of racially motivated violence.
But why do you say it's got to be deliberate? Because Article 2, death, it's a general duty to protect. Why aren't private individuals under a general duty to protect other people from death by medical negligence, for example?
My Lord, we're going to come on to the Covelli case in a moment, and the answer will become clear once we look at that. There is a distinction drawn between involuntary conduct and conduct which is deliberate in terms of the requirement to prescribe it in criminal law. And that's the answer, because it's looking at deliberate ill treatment. It's not looking at cases of medical negligence. You don't need to criminalise cases of medical negligence. You need to criminalise deliberate, serious infliction of violence that crosses, in terms of its impact and so forth, the threshold set in Article 3. Before we come to that, can I just briefly...
Doesn't the state have to have an effective system whereby one private individual avoids causing losses or killing another?
Has to have a system, but it doesn't mean that you then have to operate the system. So as long as you...
Why not? Why is the crime... I mean, crime... Death is death, and whether it occurs due to negligent building practices or deliberate action, the former is more likely than the latter.
Yes, so what the Convention does is it requires there to be a system in place, which means that in circumstances where somebody has died, and there may be an indication that has been fault on the part of an individual, there has to be a system in place, and we'll see this in Calvelli, so that there can be an examination of the circumstances of that death. But it doesn't have to criminalise that conduct. We don't criminalise, unless it's grossly negligent, we don't criminalise negligence in this country, and the Convention doesn't require it either. But in order to give effect to the prohibitions, it does require criminal sanctions in respect of deliberate criminal. We already apply here the divide. There's no question. Where the treatment in this jurisdiction is deliberately violent and crosses the threshold, the offence of GBH has been established. That's the way our system works.
But I'm sure there's liability for negligent failure to comply with building regulations.
But the Convention...
Criminal or not, there'll be civil liability.
But the Convention doesn't require the state to carry out the investigation as to whether there has been negligence. It does require the state, as part and parcel of its duty to give effect to the requirement to pass criminal legislation and introduce effective machinery to operate and implement that legislation, it does require an effective criminal investigation. That is the essential difference. And we'll see it in Calvelli in a minute.
You appreciate you've got a quarter of an hour.
I know, I am very aware of that.
Good.
NM and all the cases upon which the defendant relies, and they haven't gone through it in their all the domestic cases upon which the defendant relies, these are all cases which are, again, as we submit, cases where what was an issue was complicity on the part of the state. So again, they don't touch upon our situation. So moving on then to all that the defendant is then left with, all that the Commissioner and the Secretary of State are left with is an appeal to public policy considerations that have historically given rise to this court's decision not to impose a duty of care and negligence. So when is it appropriate for Strasbourg to think again because of the situation that exists in English law? Mr. Eady made reference to Horncastle and Manchester and Pinnock. Manchester and Pinnock is actually in the new bundle, that black file at Authorities 12. I don't need to take the court to it, but the key paragraph is in Lord Neuberger's judgment at paragraph 48, while not bound, the critical question is whether there is a clear and constant line of decisions whose effect is not inconsistent with some fundamental substantive or procedural aspect of our law, and whose reasoning does not appear to overlook or misunderstand some argument or point of principle. And in the Horncastle case, Lord Brown, paragraphs 117 to 120, volume 9, tab 85, MSP 3158. His concern there, Lord Brown expressing his concerns, which were reflected by the concerns of the court, there is no principal basis expressed for the decision of the court in Strasbourg. That was a concern. He couldn't readily identify one, and there were serious adverse consequences that would be had by following the Strasbourg jurisprudence. I'm going to show that none of that applies in this situation, but we do not accept for one moment that it is correct for this court not to follow Strasbourg, where this court itself thinks that Strasbourg is actually correct and the line of authority is correct, on the ground that the government otherwise does not have recourse to Strasbourg. And we adopt the concerns expressed by Lord Kerr in that respect. In our submission, the jurisprudence, it's clear and constant. Secondly, it's firmly based in long-established, overarching principles that guide the interpretation of all convention provisions. It is not inconsistent with some fundamental, substantive, or procedural aspect of our law. This is wrong for a number of reasons. First, the time for dialogue with Strasbourg is long since over. Strasbourg has more than once been confronted by immunity from suit in negligence on precisely the public policy reasons which the government now relies upon. Secondly, in any event, it's not inconsistent. We are not comparing like with like. A cause of action in negligence and a duty under the Human Rights Act are quite distinct in reach and in purpose. Thirdly, this court has already twice had an opportunity to consider what impact, if any, the common law immunity from suit should have on the development and recognition in our law of an operational duty to protect under the Convention. For the reasons I've given, there is no relevant distinction to be drawn between that duty and the investigative duty. So as to the first point, Strasbourg has already spoken. We go back to Osborne, volume 4, paragraph 32. Volume 4, tab 32. MSP 1353, paragraph 86.
In view of the time, it may be better just to give us the references.
I have another 15 minutes, my lord, because Ms. Moynihan has very kindly agreed to allow me a little bit more time.
Thank you very much.
So
That's fine, that's fine.
So, paragraph 86, page 1353. As regards the complaints under Article 2, the government points out that the domestic law prohibits murder and manslaughter. It argues there can be no positive duty to exclude any possible violence by third persons. While there may be a positive obligation on a contracting state to provide appropriate structures, it will only be in exceptional cases where there is, and is known to be, a real, direct and immediate threat to life and an assumption of responsibility to carry out an act or acts, that the police could be under an obligation to take specific actions in relation to the investigation or suppression of crime. Protection by law is still provided.
Okay, we've read that. This is
notwithstanding the exclusion in negligence. So they were well aware.
This is the commission, isn't it? It's not the court.
Yes, but they were well aware.
Do the court say the same thing?
The court was well aware that there was an immunity from suit in negligence. The court then at 116
right,
addresses the point made by the government.
Yeah, that we were taken to 116.
And we've looked at 116, where at the very bottom, the lines I missed out at the bottom of 116, the court does not accept the government's view that the failure to perceive the risk in the circumstances known at the time or to take preventative measures to avoid that risk must be tantamount to gross negligence or willful disregard of the duty to protect life. Now, the court will recall
but
this
morning...
But
this is talking about an identified individual.
My lord, it's talking about the operational duty. The premise of my argument here, my lord, is there is no relevant distinction for the purposes of deploying the public policy argument between the operational duty to protect life where there is a real and immediate risk, and the operational duty to investigate a criminal allegation of ill treatment. They both derive from the same source.
Yeah, the point I'm making picks up the point I made to you earlier, which you said you deal with, just putting in a marker. They do refer in this paragraph to immediate risk to the life of an identified individual or individuals.
They do, but I'm not concerned with that, my Lord. I'm concerned at the moment with the question of the public policy arguments that apply.
I understand.
And what was made clear here is that there is a public policy in English law which limits the imposition of a duty of care. It was even more clear because they had to deal with Article 6 and the question of whether that immunity from suit in negligence violated the Convention right of access to the court. And they looked at it, and they actually held in this case, yes, it does. They later revisited it in Z and UK, which we'll look at in a minute. But they did not, they were not in any doubt as to what the arguments were in relation to immunity from suit in negligence. They did not, for one moment, consider that the existence of immunity from suit in negligence was a reason not to find that there was an operational duty under the Convention. That's the point I'm seeking to make. At no point did they think it had a bearing. The same is true in Z and the United Kingdom, which is in volume 5, tab 38.
So are the two paragraphs, before you leave, Osman, the two paragraphs are 86 and 143, is that right?
86 and 1...
86 in the Commission
and
143 in the judgment, is that right?
143. No. I think it's 116.
No, it was 116 in the
You
judgment.
want
I'm sorry,
116.
my Lord. No, it was 116.
That's
It was
all
the
right.
government's attempts to limit the operational duty by reference to a standard which was very much like or consistent with the immunity from suit and negligence. And they weren't having any of
But
it.
143 does help you, because they specifically
143
refer to Hill.
better, actually.
Yes.
143 helps me. Let me
Well,
find
I think-
it. Anything that helps me.
I think Lord
I'm
Hughes has...
Just take it at a speed when there's a possibility of the slower of us keeping up, and you might get a bit of help.
I'm sorry, but we are under incredible pressure, so I'm trying to
Well,
make
I
sure
know.
I get through everything. So the government replied that the exclusionary rule, which defeated the applicant's civil action pursuant legitimate aim. Yes, exactly. This is the arguments in relation to Article 6. And that's the point I'm making. They were well aware.
Well, that's what Lord Hughes is putting.
Yes.
Fine.
Yeah,
Okay.
exactly that. And then in Z in the UK, in volume 5, tab 38,
Sorry, 30?
volume 5, tab 38,
Yeah.
page 1601, paragraph 73. We have, at paragraph 72, the government did not contest. So this was a case, this is Article 3, this was the Exon Bedfordshire case.
Okay, well, they've got the sufficient level of severity.
So we can see in 73, they read in an operational duty. They find a violation at 74 of the positive obligation, and hence a violation of Article 3. If we go back in the judgment to 44 to 45, 1580,
Yeah.
we can see very detailed consideration given to the judgment in Exon Bedfordshire as to the basis of immunity from suit in negligence. The same public policy considerations being deployed here as have been deployed by
Thank you.
the defendant in all the cases such as Hill, Michael and so forth.
Yeah, well,
And then if we move forward in that judgment the same issue arose then. This is when the court did revisit its view in Osman that there had been a violation by reason of the immunity from suit. If we go to page 1604, so we are now looking at the question under Article 6, the court's assessment, applicability of Article 6 to the Convention. And we can see that they then go through it and they find that the immunity from suit now, having revisited it and properly understood the basis upon which a duty of care is imposed, does not in fact violate the right of access to the court. That's at 101. But then at 102 and 103, they consider what the implications are for the duty to, under Article 13, to provide an effective remedy in relation to the violation of Article 3 that they have already found of an immunity from suit in negligence. And the court can see that what they don't say is, well, you need to amend your common law duty of care to make sure that it runs in step with the convention, but nor do they say, hold on a minute, we had better revisit the operational duty here because there is this immunity from suit in negligence. What they do say is, there is an operational duty. Article 13 requires the state to provide a remedy. There is no such remedy in negligence because of immunity from suit, so we have to go on and look in Article 13 whether there is any other form of remedy. And to some extent, my Lord Mance, that answers one of the questions you asked yesterday, which was, is there any case in Strasbourg where they say in terms, you have to amend, or rather the Strasbourg jurisprudence on the operational duty must have a bearing upon whether or not there is a duty of care and negligence? And the answer is no, because Strasbourg only requires that the state provides a remedy, but how it does it is up to Strasbourg. So if there is no common law duty of care and negligence, but there is an operational duty, see this case, which traverses some of the same territory, the state is not required to, our courts are not required to, make changes to the common law duty of care and negligence. But it isn't the converse.
Well, they're not necessary. Because they're not necessary.
Well, before the Human Rights Act came into force, they might have been necessary. And this case was, of course, before the Human Rights Act came into force. But even then, they didn't say that's what the court needs to do. Of course, after the Human Rights Act comes into force, then we can rely upon the Human Rights Act itself, which provides the remedy. But the critical point is that Strasbourg has looked at this. And again, 18 months later, in E in the United Kingdom, we don't need to go there, another case on the operational duty under Article 3, protective duty, no argument run by the government to the effect that no operational duty to protect should be recognised. And similarly, in relation to our own domestic case law, in Smith and Van Colley, in Michael, the question, as Lord Justice Laws observed in the Court of Appeal, was whether or not, it was the converse one, whether or not the incorporation of the protective Osmond duty into English law should lead to a lifting of the immunity. And the court considered, no, it shouldn't. But the critical point is, not for one moment did the court stop and say, well, hold on a minute, we have this immunity from suit in negligence. That in itself is a reason not to recognise the operational duty. No, in both cases, Van Colley and Smith and Michael, without question, this court and the House of Lords applied the Strasbourg jurisprudence without question. And as I've already submitted, there is no difference in principle between the two. The very self-same public policy considerations were in play in those cases as are in play here. There is, in any event, no conflict. Just as the public law duty upon the police does not cut across immunity from suit, so too the Human Rights Act obligation under Article 3. I refer the court to Lord Toulson in the Michael case, at paragraphs 32 to 33, where he describes the public law duty. There, the remedy is JR. The duty under the Human Rights Act is a similar creature. It is a very different creature from a duty of care and negligence. This was addressed most fully by Lord Brown in the Smith case, paragraphs 136 to 139, where it's worth looking at volume 2, tab 13, page 556, paragraphs 136 to 139, and the key passage, 138, there is this to be said as to why, certainly in the present context, your Lordship should not feel tempted to develop the common law in harmony with the Convention rights. Convention claims have very different objectives from civil actions, as Lord Bingham had pointed out in Greenfield. Where civil actions are designed essentially to compensate claimants for their losses, Convention claims are intended rather to uphold minimum human rights standards and to vindicate those rights. That is why time limits are markedly shorter, the 1-year limitation period under the Human Rights Act. It also shows why Section 8.3 of the Act provides that no damages are to be awarded unless necessary for just satisfaction. It is not right to say by virtue of this Article 3 obligation, there is suddenly a right to claim damages. There is not. It is only if it's necessary to afford just satisfaction. What there is a right to do is to enforce the minimum standards that the Convention lays down. And if the enforcement of those minimum standards through a judicial decision does not of itself afford just satisfaction, then the court can go on to consider an award of damages. And he finishes by saying, I'd ask the court to read the rest of those paragraphs, clearly the violation of fundamental rights is a very serious thing, and happily, since the Human Rights Act, it gives rise to a cause of action in domestic law. I see no sound reason, however, for matching this with common law claims, with a common law claim also. Well, we submit the converse is absolutely true. I know. I'm going to. So, I would also point out that there is, one of the forensic points made by the defendant is that the Osmond duty is a very restricted duty, a very narrow duty, and the duty which has been identified to conduct an effective investigation is a very, very broad and sweeping one. They are both narrow duties. Both are limited in their ambit of application and differ from a duty of care. They are both triggered by notice requirements, a credible allegation, and knowledge of a real and immediate risk. Both apply a standard of reasonableness. Both are only triggered in respect of the same, self-same conduct, that is, conduct that threatens life or limb, deliberate ill treatment. I'm very conscious I haven't looked at the Calvelli case, which I need to look at. They both impose fair balance requirements, and the test is that laid down by Mr. Justice Green in 221 and 226 of Osmond. Now, can I turn finally, and I'd like to deal with Calvelli, but it looks as though I don't have time, to the argument. Okay, I'm grateful. So I will deal with Calvelli because it's important that I do. But can I deal now with Lord Neuberger's point about, can you, if you are a victim of a serial offender some way down the track, be compensated, or rather have be the victim, as it were, of a failure to investigate him in relation to an early offence not perpetrated against you. And the defendant says that this is that this effectively cuts across the operational duty, because the operational duty is the way in which you protect a particular individual. Well, I repeat the points that I made earlier, that these duties perform preventive purposes. Each of them performs preventative purposes. They both derive from the duty to put in place machinery to prevent, suppress.
Is there any case you can point to in the Strasbourg
O'Keefe. Court? O'Keefe is as good as we get. But I would, can I ask the court to look at, firstly, the Court of Appeal's judgment at paragraph 80, and that is in core volume. Core volume at
I think it's page 4707.
So it's 4706. Duty owed to NBV to investigate before she was attacked. That's the heading. I would ask the court to read 79 right through to 81. You can see there's reference to the O'Keefe judgment.
Yes.
So, and also in the judgment of Mr. Justice Green, 4827, paragraphs 301 to 304.
Right, 27, paragraph 301 to 304.
301 to 304, and then 311. So as the Court of Appeal pointed out, these are obligations which are imposed in order to ensure minimum standards for the protection of all individuals within the community. That is their purpose. Once you accept that that is their purpose, together with the fact that both perform protective functions, then there is no reason whatsoever why, in the case of a serial offender, a failure to conduct an effective investigation at an earlier stage cannot be seen to have resulted in a victim or somebody becoming a victim of that failure at a later stage, because the operation, the investigation, must be looked at overall in relation to the overall offending of that particular individual. And that's exactly how the Grand Chamber looked at it in the O'Keefe decision itself, which is at 431 at 1290 in paragraph 173. So we have, at 173, in respect to the present case, 4 lines down, once a complaint about sexual abuse by LH from a child from Dundero National School was made in 1995, the investigation opened. So that was obviously way after the offence was perpetrated against the complainant, the applicant. The applicant was contacted for a statement. She made this in early 97. He was then charged with 386 counts of sexual abuse involving 21 pupils. He pleaded guilty to 21 sample charges. He was convicted and imprisoned. It's not clear from the submissions whether the applicant's case was included in the sample charges, i.e. it doesn't matter. However, she did not take any issue with the fact that LH was allowed to plead guilty to representative charges. Any question concerning her inability to obtain recognition of and compensation needs to be dealt with under Article 13. The point is, the whole thing, the investigation overall, is what the court is considering, not because it's absolutely artificial to look at one single investigation in the case of a serial offender. The duty to protect and suppress is what gives rise to the duty to investigate. By detecting and suppressing the criminal at point A in time, you prevent and suppress his committing offences at point B in time. And if you are a victim at point B in time, you are a victim of the ineffective investigation at point A. It is a perfectly coherent analysis and approach that was taken in O'Keefe, which gives effect to and renders real, rather than theoretical and illusory, the obligations imposed. Can I just finally then turn to the case of Calvelli? Calvelli is at volume 3, tab 20. This was a clinical negligence case. It was not a case of deliberate ill treatment or violence. Now, at paragraph 44, the government accepted that there was a protective obligation. Paragraph 44. No, I seem to have the wrong paragraph there. Which volume is it? Yeah, which volume? 20. Oh, I'm sorry, that's my fault. I'm now looking at volume 21. So at 44. Okay, sorry. I'm so sorry. Paragraph 44. Yes, so at 44, we have the government's arguments. They said, top of page 829, in any event, Article 2 of the Convention could not be regarded as imposing an obligation on states to punish offences of involuntary manslaughter in the criminal court, since the relevant domestic law already laid down civil and administrative penalties. In that connection, the government said that a criminal penalty was at the extremer ratio, and while it was true that such a penalty appeared to be the only appropriate form of response to very serious infringements of the right to life or to personal integrity, such as voluntary manslaughter, the same did not apply to attenuated forms of responsibility, such as involuntary manslaughter through negligence or by accident. So that was their position. And then at 45, they implicitly accepted that where the conduct was intentional, such serious violations of the right to life, then there would be a requirement to impose criminal liability. Now, if we then turn to 40...
That you say is in 45?
That's in 45. The government therefore maintained that once it was accepted that states were free to choose other forms of liability for less serious violations of the right to life, and that a criminal penalty was not the only form of liability possible, the reasons why a criminal penalty was not imposed in a particular case became irrelevant for the purposes of Article 2. But they've already said, when it comes to serious violations, there should be a criminal penalty. So we need that to keep that in mind when we look at what the court then said at paragraphs 48 to 49. So at 48 and so at 49, we have the principles that have been identified at 48 apply in the public health sphere too. The aforementioned positive obligations therefore require states to make regulations compelling hospitals, whether public or private. So that is, it doesn't matter if it's a state failing or a failing on the part of a private body, to adopt appropriate measures for the protection of their patients' lives. So that's a systems duty. They also require an effective independent judicial system to be set up so that the cause of death of patients in the care of the medical profession, whether in the public or private sector, again, can be determined and those responsible made accountable. So that's the system in relation to negligence. You don't need then to actually investigate, but you need to set up the system.
Well, you have to have an effective independent.
Yes. Well, when we...
Well, I thought you laid a lot of stress on the word effective elsewhere.
Well,
why doesn't that carry the whole panoply of everything else?
Yes, it does in relation to crime, as we'll see in the next paragraph. Paragraph 51, you weren't taken to paragraph 51 yesterday, but it is important. Even if the Convention does not as such guarantee a right to have criminal proceedings instituted against third parties, okay, so there's no right to actually have someone prosecuted, the court has said on a number of occasions that an effective judicial system required under Article 2 may, and under certain circumstances must, include recourse to the criminal law. Accordingly, the government's preliminary objection, which the court has joined to the merits, must be dismissed. However, if the infringement of the right to life or to personal integrity is not caused intentionally, the positive obligation imposed by the provision of of Article 2 to set up an effective judicial system does not necessarily require the provision of a criminal law remedy in every case. And then it talks about where there isn't the requirement of criminal law remedy, it might be necessary for the state to provide. So this is the beginning, this is the genesis of where we get the criminal investigative obligation coming from. But there is nothing inconsistent in this case with what the court then later said in MC in Bulgaria. It is precisely an application of this case and an application of the logic and rationale there identified. My lords, and my lady, I'm so sorry I have run over, but unless I can assist you further, those then are my submissions.
Thank you very much. Thank you, Ms. Kaufman. Ms. Brander. Ms. Stein.
Our principal submission, which we've addressed in writing, is that to view Article 3 through the lens of the common law tort of negligence is fundamentally misguided. In my oral submissions, I propose to address three further points: dialogue, public policy, and the parasitic point. Before I look at dialogue, in relation to Mr. Eadie's new point, we put in a brief note yesterday. We would caution against addressing a situation which essentially relates to those who are not before the court. But if the court wishes to address it, then we would ask for an opportunity to respond in writing to what Mr. Eadie has said. It was put in late, we haven't had that opportunity. Turning then to dialogue, the plea for an opportunity for dialogue with the European Court of Human Rights should be rejected. The case law is clear and constant. I'm not going to look at it further. Secondly, this is a question of interpretation of the Convention. It can't be said that any of the Strasbourg judgments were based on a misunderstanding of English law, nor can it be said that the court has overlooked or misunderstood any point of principle. The appellant and the Secretary of State don't rely on points of principle or points of law. They rely on English public policy. Lord Pannick suggested that the UK should have an opportunity to contend that the question whether this obligation exists falls within the margin of appreciation. That is not how the margin of appreciation works. The question whether there is an obligation to investigate crimes of serious violence perpetrated by non-state agents is a question of interpretation of the Convention. Is there such an obligation or not? If an obligation exists, as we say it plainly does, all Convention states are obliged to comply with it. The term margin of appreciation refers to the space for manoeuvre that the European Court of Human Rights is willing to grant national authorities in fulfilling their obligations under the Convention, such as when applying Article 8.2. The margin of appreciation doesn't give states an opportunity to pick and choose amongst Convention obligations and decide which ones they're prepared to comply with. Thirdly, Mr. Eadie suggested that the difficulty of policing modern societies has been ignored by the Strasbourg Court, and so there should be an opportunity to make that case. But it is clear that in cases which specifically deal with this investigative obligation, the court has had those difficulties in mind. I'm not going to turn it up, but see, for example, Milanovic, paragraphs 84 to 85, MS 1242. Second point, public policy. In any event, it is important to look at the basis on which the court is being asked to urge the European Court of Human Rights to think again. The Strasbourg Court would be asked to rethink based on wholly unevidenced and debatable assertions that the public interests militating against such an obligation outweigh those in favour. There is no evidence as to the impact of this obligation in this jurisdiction, let alone across Convention states. Given the rather tepid support for public interest factors in Michael, which was based on the common law omissions or no duty to act principle, Lord Pannick placed considerable emphasis on Brooks. As far as that is concerned, first, insofar as Brooks provides support for the suggestion that an investigative obligation would lead to an unduly defensive approach, the court acknowledged in Michael, at paragraph 122, that there is force in the criticism that there is no empirical evidence to support it. The court has, Lord Toulson acknowledged, no way of judging the likely operational consequences of imposing a duty of care. Whether potential liability would make a practical difference at an individual level was speculative. So reliance on the idea that such a duty would lead to defensive policing must fall away. There is no more basis before this court than there was before the court in Michael for finding that it would do so. Secondly, Lord Steyn in Brooks took the view that the welfare of the whole community outweighed the interests of individualised justice. With respect, genuine rather than merely forensic, the view that these interests pull in opposite directions overlooks the extent to which the interests of the community can be served by individualised justice. Systemic failings are uncovered through investigation of individual cases, as occurred in this case, and also through the judicial inquiry into the murder of Stephen Lawrence. Alternative mechanisms are not enough. See, for example, Mr. Justice Green's observations as to the unsatisfactory nature of the IPC reports in these cases, which applied an apparent burden of proof strongly favourable to the officers in question and largely exonerated them. That's paragraphs 125 to 126, MS 4769. The imposition of an Article 3 investigative obligation has the advantage of applying the less blunt instrument of standard rather than the concept of duty, and also of limiting the class by reference to the Article 3 level of severity. There are two public interest factors in Lord Toulson's judgment in Michael that my learned friends relied on. First, Lord Toulson suggested that at an institutional level, it was possible to imagine the imposition of a duty might lead to police forces changing their priorities. Secondly, Lord Toulson said at paragraph 122 that the imposition of liability would have potentially significant financial implications. So if I can address both prioritisation and then financial implications. As far as prioritisation is concerned, first, it's worth noting the tentative terms in which this policy factor was stated, possible to imagine. Secondly, we've seen in this case the lack of priority given to allegations of sexual assault. Mr. Justice Green found, paragraph 13, MS 4725, that there was pressure from borough management to focus resources on other allegations of a non-sexual nature that were easier to clear up and a resultant pressure on officers to reject complaints of sexual assault. As Mr. Justice Green said at paragraph 267, MS 4819, this pressure was imposed by the highest levels of management. In short, the statistics look better if sexual assaults are given lower priority. In our submission, if the effect of being sued and of such important findings being made has caused the appellant to reassess their priorities, that must be in the public interest. Thirdly, the court is concerned with a different duty to that considered in Michael. It is a duty to undertake effective criminal investigations into allegations of serious violent offences against the person. What, one might ask rhetorically, is a higher priority for the police than crimes of serious violence, including rape? The fact that it is a narrower duty also addresses the court's concerns in Michael at paragraph 119. Lord Toulson there expressed the concern that founding a duty of care on the public law duty on police for the preservation of the Queen's peace would create an overly broad principle, potentially encompassing, for example, offences of damage to property. That potential difficulty has no traction here. There is no difficulty finding a logical basis for confining the Article 3 investigative duty to cases of serious violent crimes against the person. Article 3 naturally does so. It does not encompass all crimes. Looking then at financial implications, it is not suggested, for example, that it is contrary to the public interest for the NHS to have to compensate individuals for breach of duty rather than being able to put that money into treating others. It is difficult to understand why this factor should be any more weighty in this context. Secondly, the interest in avoiding imposing unacceptable burdens on the police is addressed by not setting the bar for liability at too low a level, as Mr. Justice Green observed at paragraph 225, Roman 1, MS 4804. Not every error or isolated omission in an investigation triggers liability. The court applies what the Grand Chamber referred to in S and Sweden as the significant flaw test. That's paragraph 90 of S and Sweden, 11101 MS 3720. There is no danger, as Lord Templeman suggested there might be in Hill, in the court finding an inspector liable for failing to display the acumen of Sherlock Holmes. The third and final point is the parasitic one. The suggestion that procedural obligations are parasitic on substantive obligations stems from an observation of Lord Bingham in Gentle at paragraph 6. But that observation was directed to the obligation to hold a public investigation, public inquiry, in circumstances where it was not alleged a criminal investigation was required. And it is hardly surprising that if one is calling for an Article 2 public inquiry, that one might need to show an arguable breach of the substantive obligation. But if one looks at the various obligations under Article 3, the framework or structural obligation is not parasitic on any arguable substantive breach, nor is the Osman safeguarding obligation, nor is the non-refoulement obligation. The assertion that the investigative obligation can only arise where there is an arguable allegation that the state is complicit in Article 3 ill treatment of the individual is wrong in principle. Only a state can be held liable under the Convention, and only a public authority under the Human Rights Act. But torture by a third party is still torture within the meaning of the words of Article 3, to which no one should be subjected. So too in respect of inhuman or degrading treatment by a third party. The aim of the Convention is to protect individual human beings by rendering safeguards such as Article 3 practical and effective. That's what the investigative obligation does. So I would simply conclude that the Human Rights Act brings rights home so that individuals, such as these claimants, do not have to go to Strasbourg to vindicate their rights. The court should resist the call for dialogue. A less promising basis for seeking to overturn such well-established jurisprudence is hard to imagine.
Can I just ask
Yes.
a question which maybe one might put to Ms. Kaufmann, but there seems to be a clearly established line of authority that the systematic duty, if you call it that, or the operational duty to have a system which treats people properly in the medical field does not impose a liability for mere negligence.
Yes.
Is that of any relevance? I mean, certainly if you look at, again, going back to Smith and Oxfordshire Assistant Deputy Coroner, at that stage in the development of the law, we appeared to think that that was a general principle. Is it an isolated exception? I mean, I'm just in the House of Lords in Savage also, it was said, even though a health authority employed competent staff and ensured they were trained to a high professional standard, a doctor, for example, might still treat a patient negligently and the patient might die as a result. In that situation, there would be no violation of Article 2, since the health authority would have done all that the article required of it to protect a patient's life. Nonetheless, the doctor would be personally liable in damages for the death, and the health authority would be vicariously liable for her negligence. This is the situation envisaged by Powell, which I imagine is Powell and the United Kingdom in 2000, which is another European court. But, I mean, there's a range of decisions which say the same. There's Powell, there's Berzykowski in Poland, and there are at least two, well, there's Takushis, I think, which I'm not sure whether that's Court of Appeal or House of Lords, but then Savage is definitely House of Lords. So where are we? I mean, is there some coherent principle which says when mere negligence is relevant or irrelevant under Article 2 and when it's relevant?
Well, those medical cases, in my
Is it because it's not criminal? Is that the test, or what?
Well, that is certainly highly relevant. And when one's looking at the criminal investigative obligation, that is a different species of obligation from the. I mean, they are all interrelated, but nevertheless, it is different to the protective obligation that one's looking at in the context of a medical negligence claim. So if somebody has been injured, one is not there looking at an investigative obligation. So there's not been any question in those cases as to what is the standard of an effective investigation.
What about a road accident? What about a road accident in which the injured person is very severely injured? He's paraplegic as a result. And the complaint is that the other driver drove badly. That is, in fact, a criminal offence in this country. But that's incidental. It may or may not be elsewhere. And what I'm more interested in is, would it trigger the Article 3 investigative duty?
On the face of it, it would seem unlikely that would be mistreatment falling within
Why
Article 3.
Because it's not deliberate.
Well, I would have to look at the case law on that, but on the face of it, it's obviously not torture, and on the face of it, it wouldn't appear to come within the definition of inhuman and degrading treatment.
Whereas if somebody had hit somebody else with a glass and knocked them out, and the head injury had caused the same, or the neck injury had caused the same paraplegia, that would. Is that right?
Yes.
Yes, I see.
Yes. My Lord, my Lady, unless there's anything further, those are my submissions.
Thank you very much for staying. Thank you.
Thank you.
Ms. Monaghan.
Thank you. My Lords, my Lady, I actually propose to hand out a short speaking note. I appreciate that doesn't make for sparkling advocacy, but since time is short, it might help me just rush through my oral
Ms. Dane and you
submissions.
have both given up a bit of time. We understand the position.
Thank you. Just while those are being handed out, may I just introduce our submissions by saying that I propose to address the international and regional human rights instruments dealing with gender-based violence and gender equality. We don't say, my Lords and my Lady, that the Article 3 obligation, the investigative obligation, depends upon whether the harm is gender-based. We support the submissions made by Ms Halfman, but with this caveat: if your lordships and your ladyship are against Ms Kaufman and conclude that there is not any generalised investigative obligation under Article 3, then we say that in the context of gender-based violence, a different approach must be taken, bearing in mind, firstly, the specialised human rights instruments addressing gender equality and gender-based violence, and the case law of the European Court, which treats women in the context of gender-based violence as vulnerable, so analogous to children. Whilst that's uncomfortable to say in some respects, it recognises that there is a particular relationship between the gender-based violence and the subordinate position of women in the context of their relationships with, or their relations with men. So we say, specific approach taken to gender-based violence in the event that you're not with Ms. Kaufman and Ms. Stein, but our primary point is that we're with them and we endorse their submissions. Just before I come to my first point in my speaking note, I also ought to acknowledge that I have been mindful of the observation made by your lordships and your ladyship in granting my clients permission to intervene, namely that you would be most assisted by the general point, that is not the gender equality point, identifying serial killers and terrorists as a particular classes that might be affected by the outcome of your rulings. But we do say, my lords and my lady, that the general duty, or the assertion that there is a general investigative duty, has been fully dealt with, and we propose only to deal with the gender equality aspects. So the first point then in the speaking note, context, important for determining what international instruments are triggered. So context, gender-based violence, so-called because its victims are overwhelmingly women and its perpetrators overwhelmingly men. It's prevalent both here and globally. It's both a cause of and a result of women's inequality. We have produced statistics in our case and exhibited some, but for present purposes, it's necessary only to point to one or two figures, in particular that something like 85,000 women per year are raped in England and Wales, and an estimated 1.2 million women experience domestic violence in the year ending March 2016, and still around 80 women a year are killed in acts of domestic violence. Because that violence is gender-based, its victims attract the protections of specialised international and regional human rights instruments addressing non-discrimination and violence against women in particular. They're summarised in OPAs, that's already been referred to, and the references are provided in the speaking note. They include the UN Convention on the Elimination of Discrimination Against Women, and the court in OPAS made clear, this is material to developments at Council of Europe level, made clear that in determining the content and scope of the substantive articles, the court could look to emerging practices, common values emanating from member states. I'll come back to that in a moment, given developments, as I say, at Council of Europe level. Second point, and building on that, the European Court has said more than once that in the context of serious incidents of domestic violence, having regard to those specialised instruments, a duty to investigate does arise. That's in the context of serious incidents of domestic violence, and the same would necessarily be true of other forms of gender-based violence, given the source of that obligation. Lord Pannick said yesterday that OPAS was not concerned with the investigative obligation, but instead merely the protective. A study of the case shows that's not right. It was very much about failures to investigate and failures to prosecute, which resulted in the failures to protect. They are permeable, or the categories or the lines drawn are permeable, as Ms. Kaufman says, but there was a discrete obligation to investigate recognised and a discrete failure to meet that obligation. As to the duty to investigate, more clearly stated, Aremia, which we haven't looked at and I don't have time to take you to, but Aremia and Moldova, again a domestic violence case, again referring to the international materials cited in OPAS, makes absolutely clear, relying too on MC, but drawing for inspiration on the international materials as well, makes absolutely clear that there is an obligation where there is serious gender-based violence to undertake an effective official investigation and give some content to the idea of effectiveness, must be capable of leading to the establishment of facts of the case.
What's the reference?
Sorry, I beg your pardon. It's Eremia.
Oh, Eremia is 98, it's 10.
It's volume 10, tab 98. Volume 10, tab 98.
Yep.
Specifically domestic violence, specifically drawing on the international materials, identifying an investigative obligation in those circumstances, and one that requires an effective official investigation. As I'll come to in one moment, my lords and my lady, the language of effectiveness is used more than once, but in terms of gender-based violence, the court is increasingly adopting the expression due diligence, which derives from many of the international instruments, and now from the Council of Europe document, which I'll come to in a moment.
Right.
So, investigative obligation, present at least in serious cases of gender-based violence. As we've said in our note at page 5, if any of your lordships or your ladyship are following it, I don't know if it's helpful or not, but as we've said there are obvious good reasons for that. That is the investigative obligation. Firstly, otherwise the obligation to put laws and systems in place to protect against Article 3 treatment, which Lord Panic accepts exists, would be of limited, if any, value, if effect didn't need to be given to them by investigation and enforcement. And pausing there, your lordships and your ladyship will see, when you come to look at it, that in Eremia there was no question of the systems not being in place. There were laws in place. They simply weren't enforced through investigation and prosecution.
Right.
Secondly, the second rationale behind the investigative duty, and I won't go over time, my lord, I promise. I will keep to the limits of our side's time. Secondly, and something said more than once in the context of gender-based violence, the absence of investigation and enforcement results in virtual impunity for violent men in their relationships with women. This means that nothing's done to challenge the social norms that cause gender-based violence to happen in the first place. So there is a broader social imperative for investigating and penalising gender-based violence. Since Opus and Eremia, and I've just alluded to this in my opening observations, page 6 of the speaking note is being followed, since Opus and Eremia, the Council of Europe have agreed the terms of a specialised convention addressing violence against women, the Istanbul Convention, entered into force in 2014. United Kingdom has signed but not yet ratified. That deals in terms with gender-based violence and imposes specific obligations on member states. It makes clear in its preamble, I won't read you them, they're in the note, it makes clear in its preamble that gender-based violence has a very special place in human rights, because not only does it threaten women's lives and physical well-being, but, as I've already alluded to, it undermines their equality more broadly. So specialised convention dealing with violence against women, setting standards across the Council of Europe member states, and will inevitably, given what Opus says, inspire further case law and development in this area. As to the obligations, I've pointed out at the bottom of page 6, Article 5.2, and again, as I touched upon one moment ago, the content of the obligations, protective and investigative, are now being described by reference to the test of due diligence. That, as I've said, is an expression that derives from other international instruments under CEDAW and the Inter-American courts, for example, but that's all set out in Opus. So a due diligence obligation. State must take due diligence, exercise due diligence in investigating, prosecuting, and so on. And then at page 7, skipping through some of the specific provisions in the Convention, which I invite your lordships and your ladyship to look at. The most recent case, which I understand is on your bench, is Talpis.
Yes,
that was decided a couple of weeks ago. It's only in French, regrettably. I'm not going to read it to you, my lord. I am learning French as a good European, but I'm not confident enough at the moment to try that out.
It seems to be in English at the end.
That's the dissenting
The
judgment.
dissenting judgment.
So,
we
so
read
the main judgment is in French only.
But it's in paragraph 99 we should be concentrating at it.
I'm grateful. Paragraph 99 and also paragraph 104, which reaffirms the investigative obligation, but again with paragraph 99 as well. That, as no doubt your lordship's already picked up, deals with the question of vulnerability as well. So we're either in special circumstance territory, that is, gender-based violence is treated as a special class of violence, bearing in mind the specialised instruments and its impact on gender equality, and or women are viewed as vulnerable in that context because of their special situation in relation to men, one of inequality.
But this, actually, 99 explains it in terms of the potential responsibility of the state, isn't it, which you would presumably disclaim as an essential. I don't know what the facts of this case were.
Sorry, I'm...
Well, it's...
It says that the essential aim of such an investigation is to assure the putting into place of effective dispositions of internal law which protect the right to life, and when, it says, and when the
Precisely.
Yes, I see.
Precisely.
It's not just that.
Yes. And again, it's repeated perhaps more clearly over at paragraph 106. Again, I'm going to translate it, if I may, with the assistance, I have to confess, of my juniors. But again, a requirement of promptness, due diligence is implicit in the obligation to investigate, which it decides is present. Due diligence being reflecting the language of the Convention and the other international instruments. So special case, special circumstances, and or the vulnerability that Lord Panic says is required in the event that there is a general obligation arising under Article 3. Thirdly and finally, public policy. This has been dealt with by Ms Stein, and I don't need to repeat it, simply to say I recognise that I said this is in Michael as well with limited success. But I say again,
success.
but I say again, my lords and my lady, in this jurisdiction there can be no public policy imperative from departing from the Strasbourg case law. Evidence suggests that the state's guilty of significant failures. This is but one example in addressing gender-based violence. We've set out some of the relevant reports in our written case, but the failures are well known. And we say that a duty to give proper effect to the equal rights of women, those that they enjoy under the Convention, to be free from serious acts of violence, will be utterly undermined if the state is not compelled to enforce its laws against such treatment through effective investigation and prosecution. And without that, the risk is that the United Kingdom will succumb to a culture of impunity, just like that alluded to in Opus Aneremia. My lords, I did keep...
Well within time, thank you very much.
Well, 3 minutes, but there you are.
5. Thank you very much. Lord Panic.
Thank you, my lords, my ladies. As the court knows, we have accepted that under Article 3, domestic law must provide for an investigation into serious crime. And such an investigation must be conducted, at the very least, in good faith. And the question for the court, in my submission, is how much further the Article 3 duty goes into assessing, if at all, the quality of the investigation. This court knows that the Strasbourg court has repeatedly stated that it is not concerned in this context with errors or isolated omissions, MC paragraph 168, CAS and Romania paragraph 77, and there are other similar examples.
Well, I wondered whether anyone had looked at the cases which I mentioned on medical negligence, because I'm
Savage case and others.
Savage and Powell and Izakowski in Poland. I mean, that goes further than just errors which might be suggested not to be referring to negligent errors. It specifically says failure to take reasonable care at a low level is not good enough. Now, is that a principle which I think the argument against you is that that principle is confined to situations where the failure to respect life or limb is not criminal, and it's just sort of dealing with situations where there might be some failure in the state's system to look after people or have a proper system for looking after them in civil respect.
Well, I don't accept that. We all accept, I think, that the principles under Article 3 must be similar to the principles under Article 2. Hill, of course, was an Article 3 type case, and it's a very fine distinction if there is a death that all depends on whether the person has died by reason of the failures of the hospital system or by reason of being attacked in the hospital by some other patient who has a grudge against them.
Except that in one case, the state has, or as in the Romanian case should have, provided that it was a crime which should be punished and investigated prima facie by the police, whereas in the other case it isn't.
Well, but in each case, the state owes a protective duty. There's no dispute on the other side that in relation to the hospital doctor, particularly the hospital doctor who's employed by the state, who is responsible for the death of the child, Article 2 duties arise. Indeed, that's the whole point of Calvelli. So it's a very narrow distinction that my friends are depending on, and we are not introducing into the jurisprudence a recognition that there are limits to the intrusion of Article 3. It is, as I say, MC in Bulgaria and CAS which recognise that errors or isolated omissions are not the subject of Article 3. Something more than that is required. And the question is what more is required. And we emphasise, the court has seen the corpus of case law in this area. We say it is very striking indeed, first of all, that in none of these cases, none that I can identify, does it appear that the respondent government, and the various governments involved, have made submissions on the limits of the Article 3 investigative duty, in particular, the extent to which the court, the Strasbourg court, is required to assess the quality of the investigation. All of the submissions, as recorded in the judgments, go to the factual question, was there an adequate investigation? But it doesn't appear that anybody has addressed this question. And secondly, and no doubt for that reason, the court, through the sections of the court, does not address the core question of principle as to where the dividing line is to be drawn between errors and isolated omissions on the one hand and matters which do breach the Article 3 requirement on the other hand. That's the second feature of this case law. One searches in vain in the case law for any further guidance as to where the dividing line is to be drawn. And the third feature of the case law is the one that both I and Mr. Eadie addressed in opening. The Strasbourg court has not addressed the public policy factors which have concerned this court and the appellate committee. Now, a number of answers have been given to that point. Ms. Kaufmann and Ms. Stein say Article 3 raises different issues to the common law of tort. And yes, of course, it does, but our response is that if Article 3 does impose a duty to conduct an effective investigation that does the job, it's one of quality, and damages sound for a breach of that Article 3 duty, then the Article 3 obligation undermines, indeed it completely frustrates, in relation to serious crime, the public policy concerns which have in part led the courts at the highest level to exclude a private law duty of care. Article 3, like all the other provisions of the Convention, is concerned with a balance between public and private interests. The public policy concerns about effective policing are relevant to Article 3, just as they are to the content of the protective duty under Article 2. The court has seen, the court's very familiar with paragraph 116 of Osman. Even in the context of Article 2, the court does take account of the need for effective policing. We agree with Mr. Eady's submission. The values of our law should inform this court's assessment of the obligations under Article 3. Ms. Stein this afternoon took up the suggestion from my Lord Kerr, my lady the Deputy President, that there's no evidence to support the public policy concerns. My answer to that is that this case is not a rerun of the domestic law of tort. We're not involved in a reassessment of Brooks and Smith and Michael and Hill and all the other cases. The law is well settled. The policy considerations are set out in the case law which this court has seen. And it's perfectly open to my friends, to Ms. Kaufmann, if the case goes to Strasbourg, to make any points they like. But as a matter of domestic law, the values of our law are well settled. Ms. Stein also said that this case, the present case, has nothing to do with the margin of appreciation. But that's not the approach taken by the Strasbourg court in the context of the investigative duty. The court saw this morning, Ms. Kaufmann took the court to the authority, it's the Burganovic in Croatia judgment, and I invited her to read the relevant paragraph. It's paragraph 78, it's volume 3, tab 19. I don't ask the court to go back to it, just for your reference. In its page 813, paragraph 78, where the court talks about granting substantial deference to the national courts in the choice of appropriate measures, while also maintaining a certain power of review and the power to intervene in cases of manifest disproportion between the gravity of the act and the results obtained at domestic level. I'm sorry? Ms. Stein asked me to go back to paragraph 77. The court's seen it. The court's case law shows requirements of Article 3 may go beyond the stage of the investigation. But the court talks in the context of Article 3 of substantial deference to the national courts. There's no question of Article 3 being an area where the particular concerns of particular states and the means by which they comply with their obligations being irrelevant. I simply do not accept that that is the case. Now, in the context of the three limitations of the case law which the court has seen, the limitations being no respondent government has made submissions on the limits of the Article 3 investigative duty, none of the cases address in detail, at least, the question of where to draw the line, and none of the cases in relation to the investigative duty address the public policy considerations. We do say, applying Pinnock, paragraph 48, that the line of Strasbourg cases to which my friends refer and on which they rely is inconsistent with a fundamental aspect of our law. That is the public policy reasons for there being no duty of care. And the reasoning of those cases does overlook an issue of principle. That is, the issue of where does the dividing line lie. I accept entirely Ms. Kaufmann's point that Osman recognises a duty to protect people, which is, as she emphasises, an operational duty. That's the word used by the European Court. It's an operational duty. Paragraph 115 of Osman, Volume 4, tab 32, page 1382. But the point is that that operational duty under Article 3 is a very specific and carefully limited duty. The very point of Osman is that the operational duty arises and only arises from the knowledge or imputed knowledge of a real and immediate risk to a specific identified individual. Mention has been made by your lordships and your ladyship of what happened in this case, and the court has heard very limited argument indeed about the factual findings by Mr. Justice Green. The relevant paragraph is indeed paragraph 13 at page 4725. Can I take the court, please, to that in the core volume, page 4725, paragraph 13. And that's where his lordship identifies what he describes as a series of systemic failings, which he says he found went to the heart of the failure of the police to apprehend war boys and cut short his 5 to 6 year spree of violent attacks. And I say that on any view, these failings, and failings they were, let's not cast any doubt on that, I certainly don't, the Metropolitan Police don't, but they're not failings of a high-level structural nature. They are failings, in my submission, in the manner in which the investigation was carried out. They are, first of all, a substantial failure to train relevant officers in the intricacies of sexual assaults, and in particular drug-facilitated sexual assaults. I repeat the point that was eloquently made by my friend Mr. Eadie. In any case, an operational failing, a failure in the way in which one carries out a duty, can be ascribed to a failure to ensure proper training of those who are responsible for the error. The second is a serious failure on the ground by senior officers properly to supervise investigations by more junior officers and ensure that they were conducting investigations in accordance with the standard procedure mandated as set out in operating procedures. Well, again, that is an error, a failure in the way in which an investigation, a specific investigation, is carried out. Thirdly, there were serious failures in the collection and use of intelligence sources to cross-check complaints. No doubt very serious failure, but nevertheless a failure in the way in which an investigation was carried out. Fourth, the failure to maintain the confidence of victims in the integrity of the investigative process, thereby a consequential failure to create an environment where victims were incentivised to the maximum degree to bring their complaints to the police. Well, no doubt if you fail to carry out your investigation properly, that is the consequence, and very regrettable it is. 5, failures to allocate proper resources to sexual assaults, including pressure from borough management to focus resources on other allegations of a non-sexual nature that were easier to clear up, and a resultant pressure on officers to reject complaints of sexual assault. That's, in my submission, how much resources you allocate to particular types of crime is an exemplary example of a matter that is within the discretion of the state under the Bogdanovich principle.
Oh, so it's all right, is it, for the state to say, well, we won't bother investigating any rapes because,
No.
you know, they're not really very important.
No,
we'll concentrate all our resources on crimes of dishonesty. That's not what you're saying.
Absolutely not my submission. If it were the case that the Metropolitan Police or some other police force were to say, as occurred in Bulgaria, we're not going to investigate rapes, then of course that is a manifest breach of Article 3. But a dispute as to whether or not more resources should be allocated is very much a question of the operational discretion of the police authorities, and I respectfully submit it's not a matter under Article 3. Of course, if it's a gross failure that no resources are being provided, that's a different matter.
Can I just put two sides of the coin
Of
point
course.
of view? You mentioned Osman. Osman, as I understand it, once you have the requisite knowledge of an immediate threat, the state has to act reasonably. You can't say there's just some sort of structural obligation. It actually has to address the particular problem reasonably. Now, we're dealing here with a situation where someone actually has suffered criminal injury. Couldn't one say, well, it's perfectly logical that the state should then have an obligation to investigate reasonably? The other side of the coin, in a sense.
But my submission, the very point of Osman is that the obligation is being confined to a circumstance where the state knows or has reasonable cause to know that there is a specific danger to a particular individual. That person is at risk.
But isn't that this case? I mean, aren't we dealing with a case where the state knew or ought to have known that women in a vulnerable situation had sustained some sort of attack, but they couldn't pin the question whether they should investigate that properly?
But there's no suggestion that as a result of War Boy's criminality, the state knew or had reasonable cause to know that a particular identifiable person was at risk. And this is not a case.
They had suffered the risk. So
they've suffered the appalling crime, but we're concerned with the investigative duty, which raises, in my submission, entirely different considerations from a case where the state knows or has cause to know that there is a real risk that a particular person is vulnerable, is at risk of an imminent attack. One can easily see in those circumstances a special obligation exists on the state to take measures to protect that person. Here we're looking at a duty, and there is a duty after the event. And I've accepted there is a duty to investigate. There's no part of my case to dispute a duty to investigate. We are concerned with the scope of that duty. And what I'm not accepting, respectfully, in answer to my Lord's question, is that the content of that duty can be dictated by the very different duty which arises in the circumstances where an identifiable person is at risk of an imminent attack. And then the judge, at the top of page 4726, goes on to what he describes as the numerous individual omissions. So I say, when one looks at these failings, and they are serious failings, and the Metropolitan Police has accepted that. They are failings in the manner in which an investigation was carried out. That is highly regrettable. The Metropolitan Police has taken such steps as they think appropriate to try to ensure this never happens again. But I say, as a matter of law, these are not the high-level structural failings which invite, attract Article 3 liability. They are not failures to adopt systems at the relevant high level. Menson was mentioned, the case of Menson, the Article 2 case. Could I go to that? It's volume 4 of the authorities, and it's tab number 28.
Yep.
Page 1194.
Yep. It's an admissibility case.
And my friend Ms. Kaufman read up, she read the whole relevant parts of page 1203. Can I just emphasise page 1204, where the court comes to apply the principles. And in the second new paragraph at 1204, against this background, the court must have regard at the outset to the fact that the police investigation into the death of Michael Menson ultimately led to the identification and arrest of the culprits between March 1999 and May 1999. They were all convicted. They received heavy prison sentences. Then the next paragraph, the court cannot but note that the first findings of the official inquiry into the police's handling of the case appear to be critical of the way in which certain officers reacted to the attack on Michael Menson. There were very serious defects in the handling of the attack on him, which were entirely at odds with the requirements of an effective investigation as outlined above. The applicants contended this was even more serious. It was that the defects had their basis in racism, but the court says it's not for the court, in the context of Article 2, in the circumstances of the case, to pronounce on these claims, including the allegations, very serious allegations, of an institutional cover-up of police misconduct and harassment of them at various stages of the investigation. It makes 3 points. In the first place, the legal system of the respondent state ably demonstrated in the final analysis, and with reasonable expedition, its capacity to enforce the criminal law against those who unlawfully took the life of another, irrespective of the victim's racial origin. For the court, this must be considered decisive when deciding whether the authorities complied with their positive and procedural obligations under Article 2. So the court takes, having set out the principles, the court adopts the approach that if the legal system manages to find the person responsible and convicts them, that in that case was decisive. Of course, there it was done more speedily than it was, unhappily, in the present case, but nevertheless, it's a very important aspect of the case. And at the bottom of 1204, Article 2 is primarily concerned with the assessment of a contracting state's compliance with its substantive and procedural obligations to protect the right to life. The article does not guarantee as such an applicant a right to a remedy in respect of any alleged defects occurring in the discharge of those obligations. So one needs to be careful about citing principles without looking at the way in which the court applies them. Finally, my lords and ladies, subject of course to any other points the court wants me to deal with, can I just say a word or two about Miss Monaghan's contention that women who are the victims of sexual violence receive special protection under Article 3, that they're a category of persons for whom special protection applies. I respectfully submit that this submission has no support in the Strasbourg case law on Article 3, or indeed on Article 2. The court has said only, and importantly, applying Osman, that protective duties are owed when the state knows or ought to know of the specific risk to a specific woman. And if a court is to go further and to recognise women as a specially vulnerable group in respect of whom special duties are owed under Article 3, then I respectfully submit it must be a matter for the Strasbourg court and not for this court to make that step. 2 cases were referred to. I won't go back to them. I simply assert, and I invite the court to look at the headnotes in each case. Eremia is volume 10, tab 98, page 3597, and Opus, volume 9, tab 83, page 2976. In each case, the state was aware of a risk of ill treatment to an identified woman, the claimant in the case, and it was the failure of the state to take protective measures consequently that led to the liability. of the state. My Lords, my Lady, those are the points I wanted to raise in reply, subject, of course, to any other matters the Court would wish me to seek to do.
As far as I'm concerned, thank you very much, Lord Panic, just this, is the point touched on in paragraph 79 of Lord Justice Law's judgment on page 4707 that Miss Kaufman dealt with, about this aspect that if his rape of one woman the investigation of Warboy's rape of one woman had not complied with Article 3 rights, it could be relied upon a woman who was subsequently raped. Is that an issue in this case?
Well, it wasn't an issue that was originally raised in the proceedings. It's an issue that my friend, Mr. Eady, has raised. We respectfully support his submission. The suggestion that a victim can claim damages for the failure of the police effectively to conduct an investigation into an earlier case is unsupported in my submission by any authority, and it runs up against, indeed it conflicts with, the Osman principle that the state owes a protective duty to a person who is the victim of a crime if the state knows, or ought to have known, of a real risk to that identifiable victim. And there's no suggestion in this case that that Osman duty was satisfied. And the duty for which my friend contends, my submission, is in conflict with that principle.
Yes, I mean, I noticed that we have in this bundle, and I can't pretend to have studied it, Miss Justice Green's subsequent damages judgment, and I don't know whether, for instance, the damages reflected this or not in relation to NBV.
Mr. Johnson,
but
I don't know the answer to that.
Right, okay, well,
I don't answer.
Oh, I would imagine they would have done, but anyway, very well. Yes. I don't know, Ms. Kaufman, did you want to add?
I'm so sorry, perhaps I can help on that. It does address the impact upon her.
I imagined it did.
Absolutely, and what it also makes clear is that what they're being compensated for is the failure to investigate, not the original attack. So that has a bearing upon whether or not the opportunity to bring proceedings against or the CICA claim and the opportunity to bring proceedings against Warboys himself formed some...
Didn't he also find that if it hadn't been for the earlier failures, the second of these two, the later of these two victims would probably not have been raped.
Absolutely.
And
so
yes.
did he not give her damages which were partly to do with the consequences of the rape as opposed to the consequences of the failure to investigate?
No, because he recognised that that was something she had already been compensated for. So she was compensated for the injury sustained by the failure to investigate
her case. Yeah.
Her case,
well,
exactly.
That's what I wanted to make. That's what I wanted to have clear, yes. Thank you. That's
my lords
helpful.
and my lady, I really hesitate to do this.
Well, if you have something else to say, you did end early, so if there's something you want to add.
This is actually, I'm going to then use the time to one, to try and address the question that Lord Mance raised, but two, also to say this.
Very brief.
There has been a very, very substantial movement on the part of Mr. Panic today, where his case, as set out in the Statement of Facts and Issues, is there is no operational investigative obligation at all. The position now is, to the extent there is, then we don't know what the test is. Now, I simply have not had a proper opportunity because I had to address Mr. Eady's more fundamental case, which was that there is no operational duty whatsoever. I have not had an opportunity properly to address the court on how Strasbourg has addressed the requisite test.
Are you asking to put in written?
I am. I would like the opportunity
Well, I
to do
think
that.
the fair thing to do, subject to my colleagues, is to say you may. How long do you want?
14 days?
Yeah, that's perfectly reasonable. I think it's only fair to give Lord Panic the opportunity to reply if he wants to. I hope it won't be necessary to have any ping-pong, but I haven't actually asked you whether you have any
Well, I was
submissions
going
on
to say,
this.
can
Maybe
we-
a bit unfair to have...
Can we be very clear? Because I would assume the court is not going to be assisted by another round of written submissions generally.
No.
Can we be very clear what it is precisely that my friend wants to respond on? And I think she's asking for the opportunity to respond in relation to whether the Strasbourg court has addressed the specific test to be applied under Article 3, assuming that some form of investigative duty applies. I must say I'm surprised that my friend thinks that that's a new point, because the written material makes it absolutely clear that that is an area that we are going to get.
We're not
But
going
if
to...
she wants to,
not-
you
we're
do
not-
wish to shut
She
her
says
out.
that she hasn't had a chance to answer it.
We're not...
I don't want to shut her out.
No, let's not worry about surprise. That's perfectly fair. I think then you've got 14 days.
I'm very grateful.
And Lord Panic, you've got 7 days. If there's anything you want to say in reply.
Thank you very much.
Can
If
I
it
then
could be kept
just...
reasonably short, that would be a benefit.
We will make sure they are reasonably short. Lord Mance raised the question which was addressed to Ms Stein about what do we do about the negligence cases? What's the situation with these negligence cases? And if I might just address that momentarily. The negligence cases were cases in which what the court was having to grapple with was whether where an agent of the state, an NHS doctor, has performed an operation or discharged his medical duties negligently, does that breach a substantive obligation? Is that treatment that is contrary to Article 3? The answer in the cases that my Lord Mance referred to was no, negligent treatment is not Article 3 violative treatment. That is, it doesn't breach the negative obligation. The consequence of that is this: the state is not thereby required to investigate the negligent treatment, because it is only required to investigate, by way of the adjectival duty, those cases where there is a credible case of a breach of the substantive duty. If negligence does not breach the substantive duty, Article 2 isn't engaged, there's no credible case of a breach, and therefore there is no duty adjectively to investigate. That has no bearing, the fact that negligence does not engage the negative obligation under Article 2 has no bearing upon what the content of the criminal investigative duty is. That is a duty to investigate criminal conduct, deliberate ill treatment, which does cross the Article 3 threshold. And what the convention...
But you could fail to investigate by negligence. Yes. And that's the point I was putting. And it's a little puzzling to me that in some areas a state's responsibility for its own agents is limited to negligence, but in other areas it isn't.
Well, one has to look at what the duty is. The duty is to conduct an effective investigation. That is the duty. So what is effective?
Why isn't the duty to have an effective hospital system?
But there is. The duty to have an effective hospital system is why you have to put systems in place. But there is not a breach of the convention by reason of an individual negligently mistreating somebody. But there is an obligation to conduct an effective investigation. The question then becomes, well, how does one unfold what the content of that duty is to conduct an effective investigation? And as with the operational duty to protect, questions of reasonableness come into play. It's there in the operational duty to protect. You have to take such steps as are reasonable in the circumstances to protect the individual. There is an element of reasonableness in the operational duties recognised by the Convention.
Very well. Thank you very much. Lord Panic, I think, in fairness, you've got, if you want to reply to that, you can. Good.
Thank you.
Thank you. Well, we thank you all for getting through quite a lot of material in a relatively short time, and we're very grateful to you all for your all submissions. We're also grateful to all those who were involved in preparing the written cases. We will consider our decision after we've received the further written submissions which we've permitted to be made, and we'll let you know our decision in due course. Thank you all very much indeed. Court's now adjourned.